So here I pose the question whether legislative grants of rulemaking authority should always include specific guidance from the legislature. Under California's constitutional separation of powers doctrine, generally the laws are enacted by the legislative branch of government, the laws are administered by the executive branch of government, and the laws are interpreted by the judicial branch. In fact, California's constitution provides specifically for separation of powers in Article 3, Section 3. Now, with the executive branch charged with administering the law as well as enforcing it, the state agencies and departments that administer and enforce the law need to engage sometimes in rulemaking activities, which are, of course, the quasi legislative activities of a rulemaking body. And this power to make the law through regulations is similar to that and derives from the legislative branch of government by statute. The legislative branch grants through a statute or it delegates this power or authority to make laws, i.e., regulations, by the executive branch state agencies. Now, generally, when this authority is delegated to state agencies, the legislature will articulate some guidance in the use of that authority by the state agency, because to do otherwise is tantamount to an improper delegation of legislative power. And there are numerous state appellate court decisions in this area of constitutional law. Basically, is in general, an unconstitutional delegation of authority occurs when, one, it leaves the resolution of fundamental policy issues to others, or two, it fails to provide adequate direction for the implementation of that policy. One case out of the Cal Supreme Court in 1983 is Carson Mobile Home Park Owners Association versus the City of Carson. Now, in that case, the California Supreme Court stated that an unconstitutional delegation of power occurs when the legislature confers upon an administrative agency the unrestricted authority to make fundamental policy determinations. And to avoid such an unlawful delegation, the legislature must provide an adequate yardstick for the guidance of the administrative body empowered to execute the law. The court also went on to say that underlying these rules is the belief that the legislature, as the most representative organ of government, should settle insofar as possible controverted issues of policy, and that it must determine crucial issues whenever it has the time, information, and competence to deal with them. So from early on, the courts here in California have noted that the legislature has the power to delegate to a proper authority, i.e., an executive branch rulemaking entity, the making of suitable rules and regulations for conduct and transactions of that branch of government. This goes way back to 1913 in a Cal Supreme Court decision called In Re Potter. Now, despite that, the authority of the administrative agency to adopt regulations is, of course, limited by the enabling statute. In addition, the legislature can delegate authority to administrative boards to adopt and enforce reasonable rules for carrying into effect the express purpose of the statute, even though these rules include authorization to exercise discretion in doing so. Now, it's provided that the discretion is not purely arbitrary and doesn't amount to a sanction to add or to change a statute or to confer on a board the right to determine what law must be in a particular case. Now, agencies don't have discretion to adopt regulations that are inconsistent with the governing statute, or of course that alter or amend that statute, or even that enlarge its scope. Courts afford quasi-legislative rulemaking the same dignity as statutes. Now, when courts in this state scrutinize the validity of these rules, the scope of review is generally narrowly confined to determine whether the regulation, one, comes within the scope of the authorizing statute, and two, is reasonably necessary to carry out the statutory purpose. You can look at a 2005 California appellate court decision called Slocum versus State Board of Equalization. Now, I raised this because I looked at a recently enacted bill from the 2023 California legislative session that was signed by the governor in July 2023. Here, the guidance in the statute for the rulemaking body was entirely repealed. So now the statutory language only requires the board to adopt and administer a regulation. Under the prior statute, there was specific language setting forth what was to be contained in that regulation. And so it raised in my mind the query whether or not this is the right or the wrong way to proceed. In other words, this bill removed that statutory guidance. And I think that the preferred route should be that a statute include it. So unfortunately, quite a few specific provisions. It said that the board shall require licensees to demonstrate satisfaction of continuing education requirements and the following requirements at each license renewal, et cetera, that had to be in the regulations itself. So from my perspective, in keeping with a proper delegation of lawmaking authority, I think that an executive branch agency or department should have established guidance such as that which was provided in this statute, which was found in section 2496 of the California Business and Professions Code, rather than have a simple grant of authority without any standards or guidance. And I think this also ensures that the legislature's intent is fulfilled by that administrative agency ultimately in its rulemaking that it adopts.